Exactly. All right, let's go back to the health care bill itself just for a few moments. It's been said that when this bill passes, there's a lineup of state's attorneys general that are going immediately to court to challenge the constitutionality. Now, will they challenge the entire bill or just portions of the bill?
Well, that would be a strategic decision that would have to be made by the lawyers. But remember, the federal courts do not have jurisdiction over a case which says, I don't like this bill because it's unconstitutional.
Harm has to be done, and I learned that from the foxnation.com.
Harm unique from all others. So, for example, one could not challenge the concept of paying income taxes because one thinks taxes are too high, as long as the rates are uniform. But if, for example, the statute is enacted and it forces people to buy health insurance, and someone refuses to buy it, and the IRS adds to that person's tax bill what the government says is the fair market value of that, and they refuse to pay it, and then the U.S. attorney indicts them and they are prosecuted, then and under those circumstances, that person could challenge the constitutionality of the health care legislation. So even though I applaud state attorneys general rattling sabers, they would not be the plaintiffs. The plaintiffs would have to be people that the government is pursuing for not complying with the legislation. I mean, a plaintiff could also be a health care provider whose freedom is impaired, whose assets are taken away by some of the nooks and crannies and buried monstrosities in this 2,000-page piece of legislation.
You're saying there's buried stuff? I mean...
Well, no, what I'm saying is it's not obvious,
yes.
And that one has to read all of them. And if you read this legislation, as if you read any legislation, it doesn't read like a novel. It requires that you have dozens of other statutes in front of you, because the essence of these things is not only to create new law, but to amend old laws. So it is very time-consuming and tedious to read, and requires a basic understanding of the law simply to read it, much less to understand it. That's what I meant by buried. There are aspects of the law that this changes which are not in the statute itself, which require that you read and understand what is already the law so that you know what is being changed. Like the Patriot Act, for example, changes words in statutes that already exist. If you read the Patriot Act alone, some of the language seems innocuous and harmless. But if you realize what is being changed and what power is being given to the government as a result of what is being changed, you can see that it's a monstrosity.
Yes. Okay, there's a movement afoot throughout the nation. I know Alaska and Louisiana have passed resolutions to reaffirm one of my favorite amendments to the Constitution. That's the 10th. It's not necessary, because the 10th should stand by itself, or any of the amendments should stand by themselves. Would you continue to encourage state houses to reaffirm the 10th?
I would encourage them to do it, but it is a legally moot effort. I mean, it is an educational effort. It reminds the people that there is a 10th Amendment. It reminds them what it says, which is that the powers not delegated by the Constitution to the federal government are retained by the states or the people, respectively. It needs to be discussed in tandem with the 9th Amendment, which is the flip side of it, basically saying that just because we've enumerated some specific rights in this Bill of Rights that the Congress can't impair, doesn't mean that there were other rights that the Congress can't impair, since it's impossible to list all the rights in one place and at one time. Taken together, these two amendments put a boundary on what the federal government can do, a boundary that it has violated almost since day one, and at the hands of virtually every Congress and virtually every president. But the states need to do more than just reaffirm the 10th Amendment. The states, for example, need to do things like, when the federal government comes calling with a checkbook, reject the checkbook, because with the checkbook comes strings. It is not a coincidence that we have uniform drunk driving laws or uniform highway regulations in this country. Even though under the Constitution that stuff is reserved for the states. It's because the feds bribed the state legislatures. If any of the good people watching this now went to a state legislature and said, here's $50 million to repave Route 80. And if you take this money and repave Route 80, I expect you'll also do the following. That person would be arrested for attempted bribery. But when the Congress does it, the states take the money, they accept the strings, and nobody says it's bribery. Well, why not?
Yeah.
And yeah, they've been doing this over and over again. I mean, it's proven a successful tactic for them, so why stop?
Unfortunately, the Supreme Court has authorized it. The Supreme Court has basically said, if you don't want the strings, don't take the money. In my opinion, those cases are wrongly decided because the effect of this is to enhance the power of the federal government at the expense of the states and at the expense of the individuals. That changes federalism, that changes the Constitution. It's unconstitutional, it should be stopped in its tracks. But it must start with the states saying to the federal government, keep your money.
As citizens, you know, yeah, like you say, that basically means we need to support and look and vote in people to office that are willing to say, keep your money.
Absolutely. There are other things that states can do. For example, the states could actually enact legislation which nullifies certain federal statutes. And nullification is a long American tradition. The first serious nullification was the state of Massachusetts nullifying the Fugitive Slave Act, which was enacted by Congress and said if a slave escapes from his or her owner, it is not an act of kidnapping for you to restrain the slave and return that slave to the owner, and in fact you will be paid for that. The state of Massachusetts said anybody that restrains anybody else in the state against their will be prosecuted for kidnapping, and it happened and the feds didn't interfere with it. Fast forward to today, we have minor forms of nullification. The state of Arizona and the state of Indiana have told the federal government to go take a hike with respect to time zones and have decided themselves what time of day it will be in those states, notwithstanding what Congress has told them. 14 states, the most recent of which is my home state, New Jersey, have enacted laws permitting the medicinal use of marijuana, which is prohibited by the federal government. So the more these things happen, the more there is the continued recognition of the constitutional right of states to say to the federal government, you're intruding in an area traditionally regulated by the states, and we're not going to recognize it. Other things the states could do is to say to law enforcement, we're not going to enforce federal law. There simply is not enough money or resources for federal agents to enforce federal law on their own. They need to do it in tandem with the states. If the legislature and the governor of the state of Nebraska were to say to every law officer in the state, you shall not enforce federal law, the feds just wouldn't have the time or the money to come in here and enforce it. You could also require that no federal agent could serve a warrant in Nebraska without the knowledge, consent, and approval of the local county sheriff or whoever the local law enforcement entity is. So there's a lot of things that the states can do constitutionally and lawfully with political courage that would be an impediment to the federal power grabs that we're all looking at today.
But on the flip side of that, Judge, could then, at that point in time, our Governor Heinemann say, you're not going to serve these warrants, could the federal government come back and say, well, in that case, you're not getting another dime for any interstate roads.
Yes.
You're not getting another dime for education.
Yes, yes. Tip O'Neill, the great liberal Democrat that he was, the great Boston Irish Paul that he was, said money is the mother's milk of politics. Money makes the whole system run. This could only effectively be done by a state that could basically tell the federal government to go take a hike that doesn't need the federal government. Now, to be brutally intellectually honest, there could be a dark side of nullification as well. I mean, suppose the feds were doing the right thing, like say the feds were enforcing civil liberties and the state was interfering with civil liberties. Then the state would be arguing that its power to nullify would be a power to stop the federal enforcement of the 14th Amendment. So nullification can be deep, dark, and dangerous waters. It has only been used in American history to stop encroachments by the federal government. It has not been used by the states to stop the feds from enforcing the Constitution. Why? Because the feds are not interested in enforcing the Constitution.